Well, hello friends, Mark Martella here for the Dellutri Law Group. And what I'd like to talk to you about today are the three biggest dangers of not having a will. And the first danger is, look, if you don't have a will, your loved ones may not receive what you want them to receive. And keep in mind, I'm sure you'll agree with me that sometimes our loved ones are not our family. If you've had a live-in partner for a number of years and you have not provided for them in a will, they are not entitled to anything. What will happen is state law will decide who gets your assets, and that's basically based upon bloodline and relations. And as I said, in my experience, both personally and through my practice, families don't get along, and you may not want your brother, who you have not seen for 30 years, get everything if he is the sole heir, versus your partner for the last 15 years, whom you just happen to not marry. Other examples are your stepkids. Even if you're married to your wife, but if they are not your kids and you don't have a will, they are not your biological children. They are not entitled to a thing. So again, you want to provide for them if they are your loved ones, which again may be different than your family. And even your grandchildren, if you want to specifically provide for something, again, if you don't have a will, everything will go to your kids, and hopefully they may provide something for your grandchildren. But if you have a particular grandchild that you want to take care of, if you have a grandchild that you want to pay for their college, you need to have a will specifying that. So that's the first reason. The second reason is, if you have specific items that you would want to go to somebody, if you have no writing in a will to direct that, that's not going to happen. So if you have that particular ring that you want to pass on to your granddaughter because your grandmother gave it to you, you need to have a will specifying that. For example, if you had a special car that you want to give to somebody, again, that needs to be provided for. And something that people do not think about, but it is very important, is your pets. You have the beloved dog. You never know when something may happen to you. Who's going to take care of that dog? Are there funds put aside to help take care of that dog? Or is your dog going to wind up at a shelter and maybe euthanized? Again, if you provide for it in your will, that dog will be taken care of. And the third reason to have a will is basically to avoid fighting among your family members, because once you pass, if you don't have a will, any of the heirs can apply to become the personal representative of the estate. And especially, you may have seen on TV when there's big estates involved, people fighting to take control. Again, if you have a will, you name your personal representative. As long as they don't have any issues with drugs or alcohol, or financial issues, or criminal record, they will be recognized by the court as your personal representative. So those are the three reasons why you really should have a will, to avoid those dangers upon your passing. Again, I'm Mark Martella with the Dellutri Law Group. We offer a free consultation for estate planning. Just give us a call at 941-206-3700, and we will be happy to help you out. Thank you for watching.
If you found the information in this video to be helpful, then do us a favor and like, comment, and subscribe to our channel for more videos.